India Legal presents Courts Roundup.
Hello, I'm Heshe and you're watching Courts Roundup. In this program, we bring you the latest legal news and details of court proceeding. And before we begin, here's the headlines. Supreme Court stays ban on Orissa High Court's decision to ban bird animal sacrifice during Charter Yatra. About 50,000 animal sacrifices take place during Charter Yatra in Kalahandi, Orissa. Supreme Court directs Maharashtra SDMC to take a decision on Nande Gurudwara Dashera procession. State government opposes move to take out procession. Kerala High Court dismisses state government's plea against airport lease to Adani Group. Adani had won the bid against Kerala State Industrial Development Corporation and GMR Group. And in the TRP scam case, Bombay High Court asked Mumbai Police to first issue summon to Republic Editor-in-Chief Arnav Goswami as he is to be added as accused. Council seeks interim bail for Arnav.
India Legal presents Courts Roundup.
The Kerala High Court on Monday dismissed all petitions, including by the state government, challenging central government's decision to lease out operation of Thiruvananthapuram International Airport to Adani Enterprises Limited. The High Court heard the matter fresh after the Supreme Court directed for such a hearing on a petition filed by state government. The Kerala High Court has dismissed the state government's petition against the Adani Group managing Thiruvananthapuram International Airport. The state government had on August 21st filed an application against the centre's decision to lease out the airport to Adani Enterprises. The plea followed an all-party meeting in the state demanding the withdrawal of the Union Cabinet decision. Earlier, the Kerala State Industrial Development Corporation, formed to participate in the bid, had lost out to Adani Enterprises, winning bid for the airport's lease and maintenance by a relatively narrow margin of 16 rupees per passenger. The GMR Group was the third bidder. The state government will take this forward through all legal means, including petitioning the Supreme Court, said Kerala Minister Kadakampally Surendran, responding to the dismissal of the petition. The central government's decision to sell Thiruvananthapuram International Airport to a private player is daylight robbery, he added, saying the state had done everything for the airport, including providing land. Union Civil Aviation Minister Hardeep Singh Puri had earlier hit out at the allegation made by Kerala, saying the state was given fair chance and the right to first refusal if its bid was within 10% below the range of the highest bid. Thiruvananthapuram International Airport was among the 6 such facilities for which the Adani Group had won the lease in February 2019 for 50 years. The bid was invited by the Airports Authority of India for a public-private partnership model of operation based on fees per domestic passengers. While the opposition to Adani taking charge apparently comes from both the dominant political group in the state, the Left Democratic Front, and the Congress-led United Democratic Front. Congress leader Shashi Tharoor, a parliamentarian from Thiruvananthapuram, has backed the central government's PPP model for the facility. The Kerala government had last year opposed the bid to privatize the airport. It formed KSIDC only after the Kerala High Court dismissed the state's petition. The state then approached the Supreme Court, which, while setting aside the High Court's decision, remanded the case back to be decided based on merit. Bureau Report. And the Kerala High Court has directed the Custom Department not to arrest the former Principal Secretary to Kerala Chief Minister M. Shivashankar, IAS, till October 23rd, on which day it will consider his anticipatory bail application in cases registered by the Custom Department as well as that by the Enforcement Directorate. Justice Ashok Menon, who heard the plea, also directed the Custom to file a counter affidavit in this case. M. Shivashankar, IAS officer, had today moved a petition seeking anticipatory bail in the case registered by the Custom in relation to the gold smuggling case, and he is at present admitted for treatment at Thiruvananthapuram Medical College Hospital. Earlier, the High Court had granted him interim protection from arrest till October 23rd in the case registered by the Enforcement Directorate. Justice Ashok Menon took up the case through video conferencing, and senior advocate P. Vijay Bhanu, who appeared for the former Principal Secretary, submitted that he is willing to appear before any investigating authority and has also done so in the past. But 600 hours of travelling for the purpose of investigation has taken a toll on the health of M. Shivashankar, and the senior advocate said. Senior advocate K. Ramakumar, who appeared for the Customs, opposed this plea and sought time to get instruction in the matter. He is saying he is playing politics, the senior counsel said. And the Supreme Court has stayed on Orissa High Court judgment which banned animal bird sacrifices during Chatur Yatra festival. CJI S.A. Bobde-led bench issued notice in the special leave petition filed against the High Court judgment passed in January this year. There shall be an interim stay of the order in the meanwhile. The bench, also comprising Justice A.S. Bhopana and V. Ramasubramaniam, ordered. The Orissa High Court order, which banned the animal bird sacrifice during Chatur Yatra, has been stayed by the Supreme Court. Chatur Yatra is a traditional festival celebrated by the people of Kalahandi district, Orissa, and it is said that about 50,000 animal sacrifices take place during this festival. In its judgment, the High Court bench of Justice S. Panda and Justice S. K. Sahu observed that this kind of rituals reflect only cruelty, superstition, fear, and barbarism, and has nothing to do with either religion or culture, and such practices is abhorrent and dastardly. The bench had also issued direction to district administration to sensitize, familiarize, and educate the general public, particularly the tribal community, to desist from such superstitious activities. No person, including the state, shall be allowed to sacrifice any animal, bird during Chatur Yatra festival on the public road or in and around the precinct of the temple, the court had ordered. Last year, the Tripura High Court had also banned animal bird sacrifice in the temples of the state, observing that the animals also have fundamental right to life under Article 21 of the Constitution of India. While agreeing to hear the appeal filed against this judgment, the Supreme Court had granted a partial stay on the High Court order with a caveat that any slaughtering of animal for the purpose of animal sacrifice can be done in accordance with law and in areas set by the municipal authority after hearing Animal Welfare Board and Gauri Mauleki, an animal rights activist in India. In July, the Supreme Court had issued notice in a special leave petition filed against the judgment of the Kerala High Court upholding the constitutional validity of the Kerala Animals and Bird Sacrifice Prohibition Act 1968. CJI had remarked in the said case that a dichotomy existed in allowing killing animals and consuming them, and not allowing killing animals, offering them to a deity and then consuming them. Bureau Report. And the Supreme Court on Monday directed the Nandan Sikh Gurudwara Sachkhand Sri Hazur Abchal Nagar Sahib Board to approach the Secretary Disaster Management Department and for the authorities in Maharashtra to hear the plea by tomorrow. A bench headed by Justice L. Nageshwar Rao was hearing a plea filed by Gurudwara seeking permission to conduct the Sera, Takht Isnan and Deepmala and Gurtar Gaddi. While requesting for permission for the Sera procession in Nanded, Advocate Praveen Chaturvedi, appearing on behalf of the petitioner, submitted that the centre had issued guidelines and the state of Maharashtra had previously not raised objection while granting permission to a Jain temple. As far as guidelines are concerned, for marriage, 50 persons are allowed. We are also not asking for public participation. There will be 50% on a limited route, the council submitted. Justice Rao noted that while 40-50% in the procession were fine, it would not be possible to control if the procession took place on the road, and that there was a health risk involved. He further referred to the Jagannath Puri case, wherein the state of Orissa had imposed a curfew to allow the procession. Solicitor General Tushar Mehta, appearing on behalf of the centre, submitted before the bench that the centre had been unlocking the country and reopening since 30th of May. He informed the court that religious, political, social function had also been allowed from September 21st. Solicitor General further submitted the 30th September guidelines allowed gathering up to 100 persons and more than 100 persons outside containment zone, subject to condition. They could consider doing the procession early in the morning, so only those who are participating in the religious function will join. Otherwise, other people will come on the road, and the procession is 105 kilometers. They could consider holding it between 7 to 9 a.m. The bench asked the Solicitor General, would you agree that 100 persons is the guidelines, but state can take decision as per the condition on the ground? If you see the state affidavit, they have said that so many festivals which involve procession have been banned. Ganesh Chaturthi, etc. were banned. If we allow this, other festival will ask for permission. Solicitor General responded that this was not a festival which was celebrated across Maharashtra and it was restricted only to Nanded, a community with small number. The Council for State of Maharashtra then made this argument before the court. He submitted that the letter sent by the Gurudwara on 20th of September stated that lakhs of people would come. Council submitted that people from all over the country gather. Emotions are charged. It may not be possible to maintain the SOPs of the government. Our experience has shown that this kind of 50-60 people congregation are not possible. More people turn up. In response to whether the procession could be conducted in the wee hour of the morning, the council stated that despite Ganpati being the most important festival in Maharashtra and a similar request being made, the state had not permitted the same. The court at this juncture noted that the court could not interfere in this matter when the state itself was saying that it was difficult. The bench observed unlock guidelines are being issued. Now even metro is being opened. Health Minister made a statement that numbers in Kerala have gone up because of the gatherings. If there is a change in situation now in Maharashtra, go to the High Court. Things are changing. Things are opening up. They cannot keep relying on what happened earlier, the bench said. Accordingly, the Supreme Court directed the petitioner to approach the Secretary, Disaster Management Department and directed the state authority to hear the plea by tomorrow. Bureau Report. The court of the Chief Judicial Magistrate Balia on Monday remanded Dharendra Pratap Singh, the main accused in the Bihar shooting incident, in 14 days judicial custody. Dharendra Pratap Singh has allegedly shot dead a 46-year-old man, Jai Prakash Pal, during a meeting about the allocation of two fair-priced shops in Duranjpur village of Balia on October 15th in the presence of police and administrative officials. The Special Task Force of the Uttar Pradesh Police arrested him from the Lucknow on Sunday, and he was brought to Balia amid tight security late Sunday night and taken to the Kotwali police station. The police produced him in the court of the Chief Judicial Magistrate on Monday morning. In a video message that surfaced on the social media on Saturday, the accused claimed he was innocent and was being framed. And the Bombay High Court on Monday directed the Mumbai police to issue summon to Arnav Goswami, the editor-in-chief of Republic TV, in the first instance if he is proposed to be added as an accused in the FIR, alleging manipulation of television rating points. A bench comprising Justice S.S. Sinde and M.S. Karnik also recorded the statement made by senior advocate Harish Salve on behalf of Goswami that he will appear and cooperate with the investigation if such a summon is received. The Bombay High Court has asked the Mumbai police to issue summon to Arnav Goswami, the editor-in-chief of Republic TV, in relation to the TRP scam case if it wished so. The bench also issued notice on the writ petition filed by ARG Outlier Media Limited, the company running Republic TV and R Bharat, and Arnav Goswami seeking to quash the FIR registered by Kandivali police station for offences of cheating, criminal breach of trust and criminal conspiracy in relation to the TRP scam. The bench has agreed to start the final hearing on the petition from November 5th at 3 p.m. The court also directed the Mumbai police to produce the investigation paper in a sealed cover on November 4th. Senior advocate Harish Salve, representing Arnav Goswami, though pressed for interim protection from arrest, the bench observed that it was difficult to pass such an order at the present stage, when Goswami has not yet been named as an accused. Nevertheless, Salve continued his persuasion by saying that the Mumbai police had malafide against Goswami and that they might arrest him after any time. The bench noted that the police had issued summon to 7 employees of Republic TV and that none of them has been arrested so far. Senior advocate Kapil Sibbal, appearing for the state of Maharashtra and Mumbai police, agreed that summon will be first issued to Goswami. He, however, expressed that he was not giving any commitment that Goswami will not be arrested. The bench remarked that if summons are issued, there will not be a question of arrest. Salve submitted that the Mumbai Police Commissioner was acting vindicatively by giving press statement against Republic TV and Goswami, even though they have not been named as accused in the FIR. The critical report made by Goswami against the Maharashtra police for its handling of Palghar case is the genesis of the controversy, Salve claimed. He then narrated various events such as the Supreme Court order to consolidate the FIRs against Goswami over his reportage of Palghar and Bandra incident. The Bombay High Court stayed on the FIRs, the appeal made by Shiv Sena to cable operators to boycott Republic TV, the breach of privilege notice issued by Maharashtra Assembly against Goswami, and the latest show cause notice issued by Mumbai Police to him under Section 108 of the CRPC. Salve argued that the present FIR was the latest in the series of action taken by the Maharashtra administration to target and suppress the journalistic freedom of Republic TV. Sibbal submitted that the petition was premature and the investigation cannot be indirected when it was at a very nascent stage. He contended that the issue of malafide has no relevance in a criminal investigation if there are incriminatory materials. Sibbal also submitted that Goswami was not entitled to special privileges just because he was a journalist, and that he should avail the remedy under Section 438 of the Code of Criminal Procedure to seek anticipatory bail if he was apprehensive of arrest. Earlier, the petitioner had directly approached the Supreme Court with the plea. However, a bench headed by Justice D.Y. Chandrachud of the top court refused to entertain the petition and asked the petitioner to approach the Bombay High Court. It was on October 8 that the Mumbai police told the press that it has detected the fraudulent practice of TRP manipulation. Republic TV and 2 Marathi channels were said to have been arraigned as accused in the FIR. Bureau Report.
The Securities Appellate Tribunal has quashed the market regulator SEBI's order imposing a penalty on Dewan Housing Finance Corporation Limited for allegedly violating debenture listing norms.
The Securities and Exchange Board of India had in May imposed a penalty of worth 20 lakh rupees on DHFL, directing it to pay the amount within 45 days. The company SEBI said failed to create a debenture redemption reserve and invest 15% of the amount of non-convertible debentures maturing on 31st of March. A 3-member bench of the SAT, however, said SEBI initiated proceeding after the National Company Law Tribunal had admitted an insolvency application against the housing finance company and declared a moratorium. As such, no proceedings can be instituted to impose and recover a penalty, the SAT said while setting aside the order. DHFL was facing a financial stress since 2018 after payment defaulters by IL and FS Group entities triggered a liquidity crisis, drying up funds for non-bank leaders and housing finances. In November 2019, the Reserve Bank of India superseded DHLF's board, appointed an administrator and filed an application to initiate insolvency proceedings. The NCLT had admitted the plea in December and declared an interim moratorium. The SEBI argued that the moratorium could not prevent it from determining DFHL's liability arising from the alleged non-compliance. While the moratorium applies to an enforcement or recovery, SEBI's officer would only determine the liability and not seek to recover the penalty during the period. The counsel representing DHFL termed the market regulator's action as perverse, illegal, and against various orders of the Supreme Court, which prohibited institution of suit or proceeding during moratorium. SEBI ignored this decision and went ahead in a manner which amounts to contempt of court, the counsel agreed. Dismissing SEBI's argument, SAT observed that the law dealing with the moratorium is very clear and explicit, and any action or proceeding under the SEBI's Act will not be sustainable in law. Bureau Report.
That's it for Courts Roundup today. Thank you for tuning in. Keep watching APN for more updates from around the nation.
India Legal presents Courts Roundup.